Welcome. My name is Attorney Nancy D. Mendez.
And I am Attorney Michelle Castillo, and we are founders of Prosperidad Law Group. Now, the reason for this video is to explain how you can protect your estate against the courts and against Medi-Cal. We will talk about how important it is to have a living trust if you own a home here in California, and what the differences are between a living trust and a will.
Let us begin with why a living trust is necessary. In California, if you pass away and your estate is worth more than $184,500, your assets will likely need to go through probate, a public, time-consuming, and expensive court process. This includes bank accounts, life insurance policies without named beneficiaries, and real estate, which in California usually pushes your estate well past that threshold. So even if you own just a modest home, or you forget to name a beneficiary on one account, your loved ones could be forced to deal with the probate process. That's why having a living trust is so important. It helps your family avoid probate and ensures your wishes are carried out smoothly and privately. And I want to clarify, even if you still have a mortgage on the property, unfortunately, the courts do not care if you still have a debt on the property. The courts only look at the total value of the property. So in short, if we only own one home over a certain value, we are still subject to the probate process if we pass away without a trust. Bottom line, probate. I want you to think about this logically. If you are no longer alive to sign over the deed of your property to your loved ones, can you tell me how your loved ones will get this property? Unfortunately, they will have to petition the courts asking a judge, the only one with legal authority to sign this deed, over to them. This process is known as probate, a judicial process that takes place when a person has died and has left assets without any clear estate planning. Probate is a very lengthy and expensive process for your beneficiaries who will have to seek legal help. Medi-Cal. When someone has used Medi-Cal and dies, the state of California can request that they get repaid for certain services received by the deceased. This is known as an estate recovery claim. This is why you hear stories that a neighbor lost their home to the government and the children did not receive a thing. Well, it's not that the government came in the middle of the night to take the home away from the children, but it's that unfortunately the deceased did not take proper precautions to avoid estate recovery claims by Medi-Cal before they died. The good news is there are precautions you can take to avoid this, and that's where a living trust comes in. Creating a living trust and transferring your house into the living trust avoids recovery claims by Medi-Cal. So what does that mean? It means that you can enjoy the benefits of Medi-Cal without any worries of losing your home or assets when you die. Now, if you do not have Medi-Cal, and that is not a concern, I hope that saving your beneficiaries a lot of money and time by avoiding courts and all of their costs and making sure that your assets and things are distributed to the people that you want in the way that you want without any interference from anyone is of concern to you. Because that is exactly what a living trust avoids. Adding your children to your house. We often get clients who, instead of taking the time to do the right planning, decide that it is better to add their children to the title of the home. That way, if anything happens to them, the children automatically get the property. Now, in theory, that sounds like a great alternative, but most often it creates more problems than it solves. There are three main reasons why we do not think it is a good idea to put your children on the titles of your properties. Number one, liability. We love our children. However, they are young and sometimes a bit careless. If they are the cause of any vehicle accident or any civil lawsuits, the first thing that they will be coming for is your home, because that is not just your home anymore, it is also their home. And as such, it is an asset that a third party can come after. Number two, spouses. While we love and know our children very well, we sometimes are unaware of the future spouses that they will marry and how they can influence and often change the way our children behave with us especially if we do not get along with them. Well, that exposes our home to a lot of uncertainty because our children can then turn around and create their own living trust where they leave their ownership rights in your home to whomever they want, or worse, the children later get divorced. Guess what? Your property can now be included in the divorce. Now you have to prove to a judge that the property is really yours and not part of that marriage, but who wants to go through all of that? Number 3, other children. So we put one child on title and expect that child to distribute the property to the others when we die. How are we guaranteed that this will happen? What if they don't and they die shortly after us without making any distributions? Now this property can be subjected to the probate process, and if they are married, it can go to their spouses. Imagine that, a non-blood relative ending up with your home that you have worked your entire life to pay, and now your children don't get to enjoy it? Adding children to title is a messy and risky way of planning for the future. Contact our office to learn more about the tax ramifications of adding your children to title. Will. Others say, well, I will write a will, and that will guarantee that everything I have is distributed the way that I want. Sure, it leaves instructions of your wishes behind. However, let me be clear about this. A will never avoid probate. Again, a will does not prevent probate. A will is merely a letter that is addressed to the judge with instructions as to how you want simple things to be distributed, thereby making the judge's job easier. And it does not mean that the cost of probate will be any less, nor does it mean that the length of probate will be any shorter. And it definitely does not avoid estate recovery liens from Medi-Cal. So, a will in California is not the answer. Living trust. The best alternative to all of this is a living trust. A living trust is a legal document used to allow you to transfer your estate to your beneficiaries without the intervention of a judge or the costs associated with probate. This is a private way of doing things. So how does a trust work? I like to use my jewelry box to explain how a trust works. I see a trust much like a jewelry box. This box is going to hold all of your valuables with all of the instructions on how you want those valuables distributed when we die. To accomplish this, we leave someone in charge of the box when we pass away to make sure the distributions take place exactly how we instructed. This person is known as the successor trustee of our trust and can be our own children. There are many types of living trusts, but 2 in particular are the most common: a revocable trust and an irrevocable trust. Irrevocable trusts. An irrevocable trust can be seen as a box without a key. Whatever we put in the box, like our homes, we will not have the easy ability to change or remove, sell it, or refinance it. This is a special trust for special situations and not for everyone, which is why it's not the most popular. Revocable trusts. Now, a revocable trust is a box with a key. That key belongs to us because while we are alive, we control what goes in the box and what comes out. In other words, we do not lose control of our things as long as we're mentally capable. For example, if we put our home in the trust, we can always sell it or refinance it or buy more homes and keep opening our box and adding them to the box, to the trust. And how do we add things to the box, the trust? Well, the first thing we have to do is name the box. Usually it is your family's name. For example, if your family's last name is Lopez, we can use the Lopez Family Trust as the title of the trust. Now we have a name, and then we prepare a deed that grants our property over to the Lopez Family Trust, which is created by you and controlled by you. The only thing that really changes is the legal name that appears on the title. When we die, the key now goes to the person we left in charge of distributing our belongings, the successor trustee. Think of that person in charge as an administrator or manager of the trust. Because they are not the owners of anything, they only help carry out your instructions and distribute your estate to the beneficiaries you have already named and chosen. Remember that the great thing is that this person can be one of your own children. In our trust packages, we include a revocable living trust, a will for backup purposes, 3 power of attorneys for financial and medical purposes, and we record the deed that transfers the property into your living trust.
We hope this video helped you understand in very simple terms what a living trust is. That's what we love to do. Just simplify everything. Our office is casual and easygoing, yet professional and knowledgeable. Our fees are competitive and reasonable. Now that you know how important it is to have a trust, don't hesitate to call us and get the process started. We're always at your service.